first case of the morning is State versus Wysocki. Each party has 15 minutes to present the argument. The appellant may reserve 5 minutes for rebuttal. Counsel, how long would you like to reserve?
4 minutes, please, Your Honor.
All right, very good. I will make a note of that. Because we have nothing here for you to see the clock that I have, I will try to let you know about a minute left in your time.
Thank you.
Initially, I won't in rebuttal give you any more, and I'll do the same, counsel, for you, let me know about a minute left in your time. The arguments are being recorded, so when you come up to the podium, please introduce yourself and who you represent. Please make sure you speak loud enough so we can hear you, and please don't move from the podium because it's also recording you visually as well as audio. If during this case we have any use of a child, minor, or victim, I don't know if we really do, but if we would, please refer to them by initials or designation, like child, minor, or victim. With that, we read your brief. I'm ready to proceed whenever you are.
Yes, Your Honor. Good morning, Your Honors. May it please the Court. My name is Spencer Luckwitz. I represent the state of Ohio, the appellant in today's proceedings. The trial court erred in determining when it determined that 3 officers and a gesture, a point, gave rise to a non-voluntary search of Mr. Wysocki on September 22nd of 2023. And I point out only the 3 officers and their one action, their point, because every other action taken on September 22nd was not taken by a person clothed in state authority. It was taken by members of the Lorain public school system acting as employers, not acting as state agents. That's important because the facts, as they appear before this court, are that a school official, and Mr. Matt Kylan, took Mr. Wysocki from a group of children and had him, or school children, these are high school students, had him walk down a isolated road at a age preserve located in Lorain. It's a former site of a former U.S. steel mill, I believe. And as they were walking, this school official took him to meet Vice Principal Yama and School Resource Officer Mills, or Smalls. School Resource Officer Smalls. At this point, the only actions taken were at the direction of Vice Principal Yama and at the directions of this Matt Kylan. And these were school officials. Once Mr. Wysocki reached Vice Principal Yama, who was accompanied at that point by 3 officers of the Lorain Police Department, Vice Principal Yama said to Mr. Wysocki, "You have to go with these officers." At this point, no police officer had spoken to Mr. Wysocki. At this point, Mr. Wysocki had not spoken to any of the police officers.
Were the police officers standing nearby when he said that?
The police officers were behind Mr. Yama. They were still getting out of their vehicles at this point. So they were following Mr. Yama's SUV down the path to reach Mr. Wysocki, and they were there because Mr. Yama requested the presence of the police in order to give an escort off of that property and to Mr. Wysocki's vehicle because he was being placed on administrative suspension pending an investigation by the school system.
Now, the police says that at that point in time, when the officers approached him, they drove up, that there was basically no other place for Mr. Wysocki to go other than back further into this place. This was a little different than Arnold because it wasn't just a park where there was opportunity. Is that fair from the record that they kind of had him in a situation where it's difficult for him to find another way to leave the area?
No, Your Honor, I would disagree that the record does not support that for 2 reasons. First, Mr. Wysocki testified on a cross-examination that as he was walking with Matt Kylan, he made a phone call to a Steffi Kochko, who was at the nature preserve that day, in anticipation of needing a ride away from the nature preserve. Additionally, as Matt Kylan and Mr. Wysocki were walking down, they came across a City of Lorain work vehicle that offered them a ride. And if you look at the dash cam, you can actually see that work truck in the background during the entire interaction, meaning that there was an alternative way he could have left that was already provided for him, already on the scene, already offered to him, already on the scene. Mr. Wysocki knew and understood that he had alternative means of conveyance and instead chose to go with the police officers.
Well, if he had other means of conveyances and had the understanding, why did the principal then just say you have to go with the police officers?
Well, Vice Principal Yama had called the police to do an escort of Mr. Wysocki away from the students and the property and take him to his car.
I
Like I said.
understand that.
So, the fact that he said you have to go with these officers doesn't have any real bearing on this case, because he wasn't saying that as an agent of the state. He was saying that as an employer.
But, obviously we had trouble with the DVD, the CD.
Yes.
Yeah, so.
Did you receive the?
Yes, we
Okay.
haven't tried to play it yet, so we'll see that it works. But hopefully that'll give me a little bit more guidance on this. But my understanding is the police officers, like you said, were behind him. They were coming forward, and he says you have to go with them. Couldn't an argument be made that the police and the vice principal or whoever it was were acting in concert? Basically, he's saying, go with them, and he's like, I've got the force of the law behind me.
I don't believe so, Your Honor, because the video, when you are able to see it, you'll notice that Mr. Wysocki asked Officer Hargreaves as he's walking up to him, well, what's going on? And Officer Hargreaves says, I have no idea. We're supposed to give you a ride. Right? Officer Hargreaves wasn't acting at the behest, wasn't acting as an investigator at that point. He wasn't acting with the suspicion that Mr. Wysocki had committed any crime. He didn't know why he was there, except for he was told that they had to escort this person off the property at the request of the Lorain school system. This is similar to if anyone's being fired at any job and they're worried that this person may become volatile, they might ask for a police escort, say, hey, we're firing this person, can you please come and make sure that we keep the peace, right? And in this instance, there wasn't any indication that Mr. Wysocki was going to be violent, but I would like to point out that of the 6 or 7 people who were there, and 4 of them were armed, one of them was hiding his weapon, and that was Mr. Wysocki. That's why we have this option to ask people, to ask the police to come and say, hey, we're firing somebody, this will be volatile, will you please come to keep the peace, make sure this.
So that seems kind of like a community caretaker function then in your regards, that situation, the officers are coming, someone will be fired, they're there to make sure the peace is kept, and that's really all.
I would agree with that, Your Honor. And I would agree that this is an extension of that community care function. As I stated previously, Mr. Wysocki was aware that he didn't need to get into that vehicle because he was aware he had alternative means of conveyance.
Well, the officers make him aware of that. I mean, it sounds like the only thing, as I recall the officers saying, were kind of what you described is, I don't know, we're supposed to give you a ride. They didn't say, you can have a ride if you want and leave however you feel like it. We don't care. So it sounds to me they're more indicating that he was supposed to go with them.
Well, to that, Your Honor, I understand your point, but I would respond that we have Mr. Wysocki's own words. If you look at the record on page 66, lines 4 to 6, Mr. Wysocki, says when asked why didn't he ask the police if he was free to go or if he was being detained, he said, why start out on the wrong foot of playing games and exercising extra rights? I don't know what extra rights he's referring to, but I do know he has the right to be free from reasonable searches and seizures. And apparently he does too, because he realized he could have exercised that right, but chose not to. He chose to cooperate with the police at that point. He chose to get into the car. He chose to answer when asked, do you have anything on you that I should be aware of? That he has his knife and his gun and his pepper spray. Those were all actions that were voluntary. And I'd like to point your court's attention in that regard to the recent Sixth Circuit case of Lawson v. Creeley, where when a woman was fronted by 2 sheriff's deputies in a room that was blocked by a school superintendent, when said, hey, we think you have a gun on you, and she reached into her purse and pulled out a gun, the court determined that while she was seized, that wasn't a search, because she did it voluntarily. Here.
Well, that's a little different though, isn't it? Because of the fact that they specifically asked him before he got in the car. And on top of it, it's a little different because he was in, like Judge Stevenson said, a more remote place, which leads me to this question. Why did they put themselves in the position? Was there anything in the record that demonstrated why they just didn't fire him at the school instead of taking him to some nature preserve?
So,
if it's in the record.
It's my understanding that they was on a field trip, and while they were at a field trip, they received a complaint from a school student that there may be some acts of impropriety. The state has not charged any other actions against Mr. Wysocki, but they were investigating some allegation that they learned of at that time. And Wysocki felt it was prudent at that point to remove him from school functions.
So they didn't get a call that said, oh, we understand he has a gun on him?
No, it was I believe the complaint was not related to 11, Your Honor. But I would say that while, to go to your further point, that while the facts are a little different, they aren't so different as to raise very many red flags for this court. The fact that Officer Taliano, asked Mr. Wysocki, do you have anything I should be concerned about? And Mr. Wysocki volunteered the information. Yes, I do. I have this wife and this gun and this pepper spray. And that's when Officer Taliano then removed those items from this person. That was at that point a voluntary admission to get into a police cruiser. And of course, the current policy is if anyone's going to get into the police car, you have to ask, do you have any weapons? Because that's an officer safety issue.
1 minute left in your time.
Thank you, Your Honors. I will just conclude then with this. The standard for whether the search was voluntary is how a reasonable person in the suspect's position would have understood their situation, and that's from U.S. Mendenhall. I want to leave you then with a quote from the trial court, from the judge, the presiding judge, one who was having an interaction with ADA Awadala during Awadala's closing argument. The judge said, this is on page 75, lines 1 to 3, I don't know about you, but when I see a cop car, my heart goes in my throat and I'm not even doing anything wrong. If that's the standard for reasonableness, then there can be no voluntary search. And for those reasons, we ask that this court reverse the decision of the trial court. Thank you.
You'll have your full 4 minutes for it.
Thank you.
May it please the court. My name is Christopher Rewalk, and I represent FLE Brandon Wysocki. In this matter, I'll start with the facts. September 22nd, 2023, Mr. Wysocki was accompanying students on a field trip. To describe the environment they were in, this area is located on a winding dirt road behind a former steel mill. It's a non-public wilderness area that the school is taking children on a trip to. Only way out that Mr. Wysocki knew was east, the way they had come in. The other directions were through the mill, through the river, and back into the wilderness area. While there, he was approached by Matt Killian, a school employee who had taken him off the bus under false pretenses. Walking east, they approached city workers who had said, this is a long walk. It's a long walk out of here. Do you want to ride? Mr. Killian denied him that opportunity to take another ride. Yes, he had called people, but at that point, he didn't know exactly how he would get to that point. It's one thing to call somebody who's there located, and another to call somebody who's located at some other place. Mr. Wysocki was then approached by 3 vehicles. One was containing School Administrator Jama and School Security Representative Smalls. He also testified, I couldn't help but see 2 cruisers behind him despite the dust. Mr. Wysocki was instructed by Vice Principal Jama that he was being placed on administrative leave and needed to go with the police at that point. Now this issue over whether or not how they were acting, I would say that Mr. Jama and the police were absolutely acting in concert at that time. There's some separation in I believe the reply brief where we try and separate his statement, you're being placed on leave, versus the statement, you need to go with police, and whether that second was part of his administrative task. The purpose of him going with police was to complete the administrative task, to be transported off the field trip, to be transported to the school, and then to be escorted from school proper.
Did the school officials let him know that he was being investigated for potential criminal conduct, his potential school rule violation? Did they give him any idea why he was being asked to go?
At that point, and I believe the record's clear on this, he still had no idea when Jama had approached him as to what the issue was, only that he was being, one, placed on leave, and two, he needed to go with police. Hargraves then directed, you'll see when you watch the video, there's a point. It's clear from the testimony that Officer Hargraves had no other purpose in giving that point but to direct Wysocki to the other officer, Taliana. At that point, Wysocki testified he didn't feel there was another option but to leave. All of a sudden, I'm surrounded by police. Mr. Wysocki then testified that Taliano waved him on what he believed to be an order. Taliano said, "We need to give you a ride, we're supposed to give you a ride, and I need to pat you down." And it was at that point, when he was being seized, when he was being taken or not allowed to leave, and being told he needed to get into the cruiser, that the admissions as to the possible contraband were made. There's no argument that this was a warrantless search. It's therefore the burden of the state to demonstrate that it falls within the exception. We'd argue that, like the trial court found, the community caretaking exception does not apply. There was no testimony of any danger to life or personal or person or serious harm. The only exception that could potentially be...
How did the prosecutor want to analogize this to a situation where the police come where it weren't taken to escort this person out, or maybe like a domestic violence situation where they show up after CPO to let people get their clothes out of the home? It's not certainly an arrest or an event, but it's some form of just caretaking to make sure the peace is kept.
Well, at that point, Your Honor, it's the presence is one thing. But in this point, there wasn't just mere presence. It wasn't, we're going to stand by while this other task is being done. It was, we're going to take you out of here. We need to give you a ride. We're supposed to give you a ride. We need to search you before you get in the vehicle. It's not merely standing by while somebody's doing some other task to keep the peace. It's actually taking him under their control and not allowing him to leave on his own. If he would have just simply been permitted or informed that he could just walk down the road, realistically,
Or call someone to get a ride.
call somebody
whatever you want
to
to do.
bring back to him there. But in this place, we would argue that you look at the totality of the circumstances. This is not just simply 3 officers and a point, but a school administrator giving a direction, a Hargraves giving a nonverbal direction, a wave from Taliano, the imposition of multiple officers. When we're dealing with whether or not, and going from consent to the issue over what was the status of that time and whether it was a consensual encounter, Mendenhall gives us really 2 sides of the coin. One is what situation would be a non-seizure, and that is a situation where someone is in a public place, is simply questioned, and is free to leave. In this case, Mr. Wysocki is not in a public place. So the very first prong of that
Well, this is a
analysis-
public park. I mean, this is.
No, this is not a public park.
This is something that only you can get by invitation?
Yes,
Okay.
it's a restricted area, it's not open to the public.
And is
That's-
that in the record?
The fact that he is there invited on a school field trip, the fact that that school administrator Jama is waiting the police to enter the area, the fact that only city vehicles are on the area, I think gives a clear implication in his status on the field trip that this is not a public area.
But there's no specific question, anyone on the record saying it is a public park to the officers or anyone explains the nature of this location?
I think the nature of it as a wilderness area, a winding dirt road, an abandoned steel mill property, and I can say nobody on the record gives any implication that this is a public area. So we believe there would be some need for the state to show that this is a public area in order to reach that one half of the Mendenhall test. The other half of the Mendenhall example gives examples of when a seizure does take place, and that is a threatening presence of several police officers, display of weapons, some physical touching, and the use of language or tone to imply that compliance would be compelled. We have the presence of 3 armed police officers. Now, there have been cases in this district where officers who are armed but still in their vehicle, it's not held to that same standard. But here there are 3 officers, both armed, all 3 armed, all 3 out of their vehicle. There's physical direction, pointing, orders to him on which way to go.
All by the officers or by the school official?
Both, but even if we're constraining ourselves to the officers themselves. Now, I would say it's in conjunction with the school official, where from Mr. Killian to Mr. Jama to the officers, through both of them. But even if we just constrain ourselves to the officers, we're still having him being approached by 3 armed officers, 2 police cruisers blocking their way. And I know in other cases in this district that, such as state versus, other cases, there's been an issue of where the officers are located. The fact that 3 officers and the cruisers are all standing between him and the only exit, I believe is telling us whether or not a reasonable person would feel that they were free to leave.
So you don't think this case turns on the school officials being there? Had the school officials not been there in the same circumstances, you would still say?
It's an additional factor in the totality of the circumstances as to whether a reasonable person would believe that they were not being seized at that point, and whether or not Mr. Wysocki, a reasonable person in his position, would have felt they were free to leave once being engaged by the officers. But even looking at the officers' behavior on their own, knowing what Mr. Wysocki knew when coming into the situation, we believe there's clear indication that he was seized at that point when Hargraves points, when Taliano waves, and he's taken over there, and Taliano gives him the direction. We're supposed to give you a ride, we need to give you a ride, I need to pat you down. Those aren't requests. It's a need by the officer, which gives a feeling that he would be compelled if he did not obey.
Prosecutor made some comments that rather than saying that he felt compelled, that he just didn't want to raise these rights at this point and get off on the wrong foot. And that's a bit different than saying I'm not compelled. I know I had rights, I just didn't feel like asserting them.
Well, it's one thing to not feel like asserting where you would be comfortable. I don't think it was, I just am sitting here and waiving my rights freely and voluntarily. It's a situation where, do we require defendants to escalate situations with the police in an effort to assert their rights? And in this situation, Mr. Wysocki even testifies, I'm here surrounded by police, what was I to do? I can go backwards, start swimming up the river, I can go back into the wilderness area, or I can somehow force my way through these police officers who are standing in front of me. And I don't think we want to put citizens in a situation where in order to assert their right, they have to be antagonistic towards police.
At times we do, though. Certainly if we're talking about the right to assert, for instance, to assert your right to counsel.
Yes.
You could be in a room with 4 police officers, you have to assert your right, even though they tell you have it. It doesn't automatically start. That's something you have to assert to say, no, I'm not going to talk to you, I need a police officer, I need an attorney. The same here, if you don't want to be searched, you have the right to say, I don't want to be searched. Thank you very much.
I don't think the requirements are that you have to assert those rights as clearly as you do the right to counsel. First, I think there's additional protections where you have to be informed of your right to counsel, even if you're waiving it. In this situation, we don't require people to be apprised of what state of seizure they're in order for them to fully be knowing and voluntary. We sort of assume that they can tell from the situation. And an ordinary person in Mr. Wysocki's situation, where he was approached, taken under false pretenses off of the school field trip, approached by his supervisor through the school, which we would contend is part and parcel to this, but even if not, approached by the officer, directed by the officer, waved over by the other officer, taken to the car and told he needs to do that. We don't believe a reasonable person in that situation would feel appropriate or able to assert their rights in that situation. As we noted, that this is all based on the objective reasonableness of the situation. We believe there's ample testimony to support that view, and we would ask that the court uphold the decision of the trial court in this matter. Thank you.
See no further questions? Thank you.
Judge Stevenson, you inquired as to whether or not there was any requirement for Mr. Wysocki to assert, his ability to say, I don't want to be searched, or I don't want to get in your car. I would like to point out that in his own words, and it's on page 66 of the record, that Mr. Wysocki stated on cross-examination, I started to gather that something serious had been accused of me, but I had nothing to hide from. So I figured I would comply and try to corroborate and get through this situation.
But they're just talking about what the underlying circumstances were. All we know is that they were called in, that a call was made that he had engaged in some kind of inappropriate conduct or something or other. So
Yes.
He was saying there, wasn't he, that he was only, he wanted to cooperate because he'd done nothing wrong in regard to all that.
That was saying in his regard to whether or not he was going to decide to get in the police vehicle voluntarily. So at that point, he's, there's 2 cruisers, 3 police officers. At that point, he's saying, I didn't do anything wrong. I'm going to comply and work with these officers, get into the police vehicle voluntarily, Your Honor. And I bring that up, because while I'm not sure if we want to be in a situation where every person has to, at every point, when there's an interaction with the police, say, these are my rights, I'm exercising them. Regardless, there's also nothing here, no case law from this district or this state that says police are required to say, you're free to leave, you can go. State Guard actually says explicitly that police aren't required to let a suspect or a defendant know that they are able to leave police interaction.
Doesn't it turn that on what the court would view, what a reasonable person would think under these circumstances?
It does, and a reasonable person under these circumstances, Mr. Wysocki himself seems to be a reasonable person, and you'll notice when you watch the video, in the 3 minutes it takes from the arrival of police to Mr. Wysocki being searched, he apparently had the ability to think to himself, I'm going to work with them, I don't want to exercise my extra rights, why start on the wrong foot, right?
But if we're looking at what a reasonable person would do, are we concerned with what Mr. Wysocki said? Or we're looking at what a reasonable person would have thought in the circumstances, whether Wysocki said X, Y, or Z, how helpful is that for a determination what a reasonable person would do?
Yes, John, I see what you're saying. So a reasonable person in this situation, we have 3 police officers who don't brandish weapons, they're armed, they're not brandishing their weapons, who aren't shouting at Mr. Wysocki, go over there, who aren't saying, we're here to take you to X place or Y place, who actually say to him, we don't know why you're here, we're told to take you a ride, and the point is, this guy, he's to be the one who would give you a ride. He wasn't saying, go over there, he's saying, hey, that's the guy I gotta talk to, right?
Are you saying that in this video, when we watch it, nobody instructs the appellant to get in the car and go with the police officer?
Well, I'm the appellant. No one instructs the appellee to get in the car and police officers. No, Your Honor. The only thing that the police instruct Mr. Wysocki to do is talk to that officer. That's it. That's the point. That's the only thing.
He says at the time that he's pointing, talk to that
At the time
officer.
he's pointing, I don't know why we're here. We're told to give you a ride, as he's pointing. That's it.
But this is after the vice principal said.
This is after Mr. Wysocki had the conversation with the vice principal, who was not acting with state authority.
But the 3 armed officers were there behind.
There were 3 officers there. One was talking to Mr. Wysocki, kind of maybe that's far away. Another was a little bit behind and to the left, and the third was maybe 10 to 15 feet away walking up. So at that point, what a reasonable person would think, maybe a reasonable person would ask the question, why? What's going on? Can I go? That never happened. And for those reasons, the state asked that you reverse the determination of the trial court because this was not an unreasonably involuntary search. Thank you.
Thank you. On behalf of the court today, thank you both for your presentation. The court will take the matter under advisement and make a decision in due course. When we make that decision, it'll be made by the clerk of court and also be available on the Ohio Supreme Court website. Again, thank you, Bob.